I want to spend a little time discussing alternatives to litigation, because litigation, again, is so time-consuming, so expensive, so ruinous to your lives. Let's see what we got in lieu of thereof. First of all, the first reaction to an aggrieved party is to want to take legal action against the other party. You know, I don't care. It not only happens in a bar, but it happens in negotiations. I've even been in a situation where I'm dealing with the Internal Revenue Service, in which the IRS would say, "We're going to get you guys in jail." Well, it's not exactly the best way to have a relationship between parties, especially if you're trying to negotiate something. But it does, when people get angry, the first thing you think of is sue the other side. Our costs are bogged down today, and as a result, it does take years and thousands of dollars before trial. As I mentioned, business trials many times take 2 or more years before you get the trial, and then if it's appealed, it's going to be taking more time. The good part is usually civil cases are settled before going to court, as the parties can control their destiny. But once you get into the court itself, the actual assurance is going to be a winner and a loser. So no one wants to be a loser. It might be a good idea to settle. And I think one of the nice parts of the 2 years it takes to get to court is it gives you plenty of time to get rational and come up with a settlement, so that you don't have to be a winner or a loser. And you know, each side gives a little bit. You both lose a little bit, you both win a little bit. Is much better, I think, in general than the straight winner-loser. Our legal system has several alternatives to litigation for business disputes that are covered on the following slides. The major advantage of the alternative over litigation is the parties selling are familiar with the subject matter, and thus complex business or technical matters are settled by experts and not by judges and juries who have no conceivable way to understand the non-legal issues. For example, just the concept of fiduciary, which is pretty straightforward to us, the jury has no idea what that means. It's hard enough for them to come up with understanding what a reasonable person is, or a reasonable investor is, a reasonable man. So let's keep it to the experts, and I found that's true in the business world. I bring in experts in the field. They can come from the academic area. In many cases, sometimes they'll come from being leaders in the business community, whatever. Negotiations. It's the most direct and least intervening method, where there's a direct contact between the parties to a dispute and representatives in order to reach a settlement. And again, you have full control over your destiny, and because you have more control and you actually make the decision, you're more apt to carry it out. Let's face it, if I'm told to do something and I don't like what I'm told to do, I try and figure a way out of it. Where if I'm part of the decision making and doing it, I'm more apt to accept it. And my favorite story is everybody in the office decides they're going to have a summer picnic, and everybody's involved in it except you, because you've been busy with a client and out of town. So when you come back, they say, "Oh, by the way, Jerry, we're going to have a picnic next weekend, and we think you would be bringing the pickles and the olives." Well, Jerry hasn't been involved in it, so he's getting initial response is being defensive. "Well, I'm busy that time. Won't be able to make it. I'm sorry." And if he does go, he'll find some reason what's wrong with it. But if Jerry's part of the decision-making, he has a vested interest in making it a success. And that's what I like about negotiations. You have a vested interest on both sides to be successful. It doesn't exist if we're not in a negotiation. Second method is mediation. This is where an independent, neutral third party helps the disputed parties to reach agreement. The method is useful if the parties dispute have major disagreements, have got to the point where they don't trust each other, and a lot of times the mediator has been able to get information from parties that give feed to each other to show, yes, they were really trying to get along with you, etc., etc., and they try to find out common areas of agreement and hope that we can get the two parties to get back together and settle. Sometimes the mediator is actually settles by representing the parties to each other. Sometimes they get the parties back together. It doesn't always work, as you can figure. It's people have it between married couples, they have it between children and their parents, they have it between bosses and employees, they have it between members of associations and the association. Mediation is found all over the place. The big advantage to me in mediation is I control my destiny. I don't have to cave into what a judge or a third party wants to do. And if I wasn't able to reach negotiations, I get a second chance with mediation because we're having parties work with us to try and find areas of commonality. And many times areas of commonality can be found because people don't want to admit to what their best position is. My best experience with this is I was in a business arrangement and I was in we were in a bar saying goodbye to each other because I was going to get on the airplane. And when I was getting ready to get on the airplane, in the bar, we told the bartender, we're each going to give you our position. If they overlap, I want you to tell us what the overlap average is. If they don't overlap positions, then just tear up papers. Well, it turned out we had a big overlap, and we had a nice settlement. And I missed the plane, obviously, because we had to celebrate the settlement of a very stressful negotiation settled by a bartender. Again, he served as a mediator. Conciliations are quite similar to mediation, but the main difference lies in the fact that it adopts a more intervening technique, as the conciliator is the type of settlement seeks by all means to enhance solutions, propose possible options, and clarify potential privileges in the settlement. Usually they are someone in the field, so if it's a case where you have, rather than a professional mediator, you have someone who knows the field you're in, for example, the financial field, or if this engineering field, scientific field, educational field, whatever, they are experts in it. For example, if you have problems with your clients, retired financial planners are great for the conciliation. They understand what's going on. They probably have gone through it themselves, and certainly much more knowledgeable than, say, a professional mediator who knows nothing about what actually goes on with a financial planner and their client. Another example that I find much better than judicial, I've used it quite often in the business world, is arbitration. It's very similar to litigation, but it's a great deal of freedom for disputed parties to determine how to form the arbitral tribunal. It's much more flexible. You're not set by precedents. You can have any type of rules you want. You can create your own rules of procedure. You can just leave it wide open. It's used throughout the entire world as a method of settlement, and basically what it does is it has either a formal board, which could be through the New York Arbitration Board, and there's one for international labor boards, arbitration boards rather, in Brussels and in Switzerland and some other places, which are very formal and they take as much time as courts. Or you can have informal ones that can be done very simply by having someone who's an expert make the decisions. So let's say that we have two financial planners who are arguing about what type of interference each had on another in the area of clients. Or you might pick someone like a college professor at a university who teaches financial planning, who's experienced in financial planning, to serve as the arbitrator. Or you could have each of the sides pick an arbitrator, and the two arbitrators, one from each side, picks a third party, the three serves as arbitrator. You listen to decisions, and after hearing them, you get a decision. And it can be very complex matters handled. Back when I was in the aerospace industry, we would have advanced physics that was such that most of our scientists didn't understand, very few did, and it would be an area of issue between us and the customer, or us and our suppliers, and we'd get hold of someone at Caltech or someone at the UCLA Engineering School or SC Engineering School, have them listen to our issues, and they make a decision. And my favorite story along that line is we had for 6 months, we were having our lawyers talk to their lawyers, and finally management said we're getting nowhere with the lawyers because the lawyers don't understand what they're talking about, and the last thing we want to have is a jury trying to listen to it. Therefore, they contacted a professor at Caltech who had taught physics, and he sat down with us in the afternoon about 4 o'clock. After hearing both sides, he said, why don't you all go to supper and come back? We came back at supper, and he had a decision for us. Now, the decision could be for the plaintiffs, for the defendants, or it could be for both sides. It could be splitting it some way. It's really up to the arbitrator what they think is fair in the situation. An excellent approach. Again, we use experts in the field, and I certainly find that helpful in even such areas as taxation, because unless you go to tax court, courts and juries do not understand tax law at all. So if I can get an arbitration type situation, much prefer that. And if not, then I have to deal with the tax court. Arbitration decisions, fortunately, are enforceable worldwide. That's not true of mediation. It's not true of negotiations, but it's true of arbitration. Precedent, our judicial system isn't required. In fact, they don't necessarily go by the laws of the country you're in. And I might know judicial has a winner or loser, whereas arbitration can decide on a settlement what's best in the situation. Now, in the real world, most arbitrators, and I have been one myself at times, you try to make each party gain a little or lose a little. You don't make it so that one party gets everything and the other party's a loser. Because what they'll tell their friends is, well, don't go to him because he's going to decide only for the buyers, or he's only going to decide for the sellers. We want them to feel both sides lose a little bit and both sides gain a little bit. The only thing I can say bad about arbitration is your parties lose control over the settlement. It's controlled by a third party. Some common legal issues for practitioners. A firm should have procedures in place to train personnel in the following areas: protection of client information and documentation. I can't believe when I walk in firms today where I'll see client folders sitting on a table, someone on a bus or train looking at client files as they're going and sitting next to people who shouldn't have any interest in the topic. And I always, when I see that on a train or a plane or bus, I say, I wonder if the person sitting next to that individual reading those files is a spy or a private eye trying to get information. And I wouldn't be surprised in many cases if it isn't. You really should protect client information, treat it as you would private documents, and also your client files should be treated as special documents. In fact, documentation of all contracts and all contacts with clients should be treated as proprietary. It should not be laid around. And if that includes documents you keep that you don't give to your clients, and copies that you have the clients, that you send to the clients. Due diligence before meetings with clients and delaying answers to clients when due diligence wasn't performed on the topic. No hip shooters. In other words, don't make a decision in a meeting that you haven't thought out in advance. And it's much easier, as I do all the time, what you've got is a complicated subject that we have continuous changes in the rules and the situation we're in, and I really wanted to check it out to make sure I give you the right answer. So I will send you a letter in the next 48 hours, or I'll send you an email next 48 hours with the answer. That is much better idea than hip shooting. And I think, although the clients always like answers right away, they understand and appreciate the benefit of you doing the research you need. In fact, I do that even when I don't need research, because it gives me a second chance to talk to the client and be able to get better information from them and hopefully convince them more that I'm the right person for them. Training on how to avoid libel and slander, which are types of defamatory statements. Libel is a written defamatory statement, and slander is a spoken or oral defamatory statement. There's some industries, there's a lot of slander and libel, I think in primarily the political areas, but you find that also in many industries where it's normal for people calling each other's names. Fortunately, our industry is not that way. I think we're very professional, and we should continue to be professional. And certainly if people do start to use slander or libel, I would hope people take action against it. Agents and independent contractors need to have detailed written instructions and training as to authorized duties and authority. And I say the same thing as applies to employees. You should know what your job is, what your restrictions in your job is, and when you're to do your job, if there's kind of special rules, and you should be sure that the documentation is accurate and up to date. I've signed consulting agreements with companies, which was the same form they used for the 50 different kind of consultants. It was a lot of motherhood, but it didn't say anything. And it was actually useless as far as really defining specifically what my job was to be. I could say that maybe they don't understand what my job should be. I think being more realistic about it is a case of they just like that standard form and don't realize that they're hurting themselves by not being more accurate. All supervisory personnel need training on documentation, sexual advances, harassment, protection, whistleblowers, etc. I also recommend it for all employees, but again, the supervisor is the most important. All accusations must be investigated. Once, when I was early in my career working for a large company, I was a supervisor, and something was brought up, and I thought that's the stupidest thing I ever heard. So I kind of ignored it, and 3 months later it became a big deal. It's something I shouldn't have ignored, and I think I learned very quickly that in the future I better not take anything for granted. Everything's got to be treated seriously. No matter who says it and what they're saying, we should check it out. And again, all accusations should be investigated. Disciplinary action must be taken. It must be meaningful. Slap on the hands, don't do anything. I found that what works very successfully is time off without pay. Again, that should be included in employee manuals, that if you do certain things, you're going to be penalized. And it's not just a mark put in your personnel jacket, but actually action that will financially or career-wise affect you. Any verbal written discussions with suppliers, clients regarding exclusivity should be cleared by the attorney. And that is almost begging you to do that, because it is so important. I've half the type of times I hear problems in profession is because of employees I'm stealing clients from each other, and it does run up a lot of problems. And a lot of it depends, of course, on the agreement you have with your employer, but most employers are smart enough to make it so that you just can't run off and steal clients from them. Positions required as a result of laws, regulations, and industrial practices. We're going to spend some time on that now. Some of these you probably haven't heard of because they are relatively new, and say some companies just refuse to acknowledge the need for it. Other companies are more progressive are doing it and are finding that it's well worth the time and money they're spending. First one's compliance officer. I actually ran into that when I was working for government contractors many years ago, where someone was responsible to make sure the company was in compliance with the laws of doing business with the federal government. That was the simple definition I was given, the job. And that was reported directly to the president. So for me, which was, I was at the time a director, that was a nice boost up, because instead of reporting to a division manager or a vice president, I reported directly to the president. And that's got me a lot of experience as well as attention that I really liked. So what is that compliance manager officer? It's sometimes called a compliance manager. It makes sure the company is conducting its business in full compliance with all state, national, international laws and regulations pertaining to its particular industry, as well as professional standards, accepted business practices, and CFP requirements. Therefore, it is a very broad responsibility covering a lot of rules, and it's something where you have to keep up with the latest rules. You have to keep up with the latest changes that the CFP board is doing to their ethics standards and to their procedures and the conduct and etc. Also, if you belong to trade associations such as National Association of Investment Advisors or a other type of professional organization, they regulations and rules, etc., must be followed in addition to all of the others we mentioned here. The compliance officer typically reports to the top person in the organization. If they don't, it's kind of a waste of time. And I've seen it where it was reported to some manager or office manager, and you might as well not have it. It's just a waste of time. It's got to report to the top so they have the independence to be able to do things. And they can order job description being written up, and they can order changes to material, which you can't when you're working for someone other than the head of the entity. There's an ethics officer, separate type of job, serves as the organization's internal control point for ethics, improprieties, allegations, complaints, conflicts of interest, and provides corporate leadership advice on corporate governance issues. If you ask me, this person's job different from the compliance officer says, are we following the rules? Ethics officers, are we doing the right things with our clients and suppliers and our employees also? Right thing is not necessarily what the legal requirements are or the requirements of the trade associations, and therefore they should be looked at separately. And again, the ethics officer could be at the top of the organization. It could be located wherever in the organization. There's sort of what I would call the godfather of what's the good to do and what isn't good to do for the organization. Another one we have is ombudsman, is the official of the firm who is charged with representing the interests of firm and clients by investigating and addressing complaints of clients and employees. Typically, the duty of an ombudsman are to investigate complaints and attempt to resolve them, usually through recommendations or mediation. Ombudsmen sometimes also aim to identify systemic issues, systemic issues, depending on how you use the word, leading to poor service or breaches of client and employee rights. And again, this office is also a little bit different in that this is a complaint desk. And I think the retail industries, especially retail stores, have found this a very important job. And I find that a lot of the online stores today, believe it or not, have omnibus persons there to solve when you got a problem with that. So it certainly would be a good idea for us, because we do have, when clients or employees or somebody has a complaint about what we're doing, and we can resolve it without going to court. In fact, I've talked to omnibus persons who say they have precluded most of the litigation that the company used to have, and they can show me data that showed number of times a company had to go see lawyers for legal advice or handle a lawsuit before versus how much after the omnibus position came in place and was able to settle on their own. So they did make a big difference, and certainly we would expect to see the same thing in the future. Some closing comment. Practitioners have a good personal ethics and follow practices required by the board, should have a minimum issues with clients and employees. And quite honestly, I think that the board is very good at having a good set of conduct, a good set of ethics, etc., that is very comprehensive. And I'd like to say it's almost as good as the Boy Scout Creed or the Girl Scout Creed, because it is very comprehensive and very useful for everybody. And I think everybody in the industry should not just give lip service, but should actually be aware of and follow it. And that's, again, that once a year, a minimum meeting with the employees going over what the board requires. In conclusion, we hope you understood that litigation should be avoided for many reasons, not least of which you're going to lose a client. I don't think I mentioned losing a client at the time, but that is certainly one of the losses. Again, it's very financially draining, and it's very socially draining, and it's also ties up a lot of time. There's really nothing that really comes good out of litigation unless you're a lawyer getting paid. There are many things that a practitioner can do to prevent legal issues with clients, and we've discussed many of them. I'm not saying I covered everything, but I covered things that I have experienced in the years. Third, there are alternatives to litigation that are more appropriate for the type of business the practitioner has. Certainly we have arbitration in most contracts today as a means of settling. I much prefer negotiations as being by far the best way to settle. Not always are we in a position to be able to negotiate. For example, if a party doesn't want to negotiate, there's no way you're going to reach a settlement. If a party doesn't want to negotiate, then you're forced into either arbitration or court situation. Maybe sometimes a mediation can change people's minds, but in general, it becomes very difficult once a person just doesn't want to settle, or your positions are so far apart that they can't be reached. Again, arbitration or judicial may actually become required. And our industry, as well as many other industries, have established new positions that have been established to help avoid litigation and take care of our actions internally in the company, and as well as make us better internally in the company. I think the best thing that came out of these new positions is we started to see very well-written job descriptions that cover exactly what we do and are kept up to date and tell employees exactly what they can and cannot do. And with that, I wish you the best of luck.